just as a summary, so the typical disputes, as I said before, in respect of functions, so there's not a clear definition. So it's somehow moving which functions are within the responsibility of the distributor and which are not. Then what are the transfer pricing methods applicable? So you can discuss this as well with the tax authorities. Typically the comparables, either they are absent at all, or if you have comparables in respect of margins, it's typically the discussions, okay, which company or which comparable can you still include and which can you take out? A huge issue is reorganizations. So the standard setup is, and this is even explicitly mentioned in the chapter 8 of the OECD transfer pricing guidelines, is the downsizing. So if you have a fully fledged group entity dealing with distributions, to downsize it to a LRD, you typically have lower profits going forward. It's one issue to discuss the setup going forward. One of the main issues here is, of course, is the downsized entity, is there some need for compensation to Austria in this respect? Because if they took some marketing functions in the past, if they developed some marketing intangibles, then of course Austria says, well, there was a value generated in Austria. If you take this out wherever it goes, then there should be compensation here. From the other direction coming, there's also the issue of non-recognition of losses. I think Catalina will go into this in respect one of the cases she's presenting from a little bit later. And then, of course, from a practical point of view, and this is not only in respect of advisors, so when Catalina and I are dealing with these issues, but also, of course, for our clients and for the business. So typically, when do you consider all of this? This is, first of all, not only tax planning, but also business planning. Where do you want to have your hub from a business perspective? When you plan it, make clear which functions are taken care of by whom. In Austria, the possibility of a tax ruling that can even be binding in respect of the transfer pricing setup. Here we see in discussions with clients, it's very important to be very clear on the functions and the risks, who takes what basically at the end. This also leads to the second item, the documentation. These days, it's very important. So this is the standard issue that we see here, that business is rather poorly documented in the past. It's people have changed. The people who were responsible for setting up a LRD structure are not there in the company anymore. And there's many times not sufficient documentation to really follow up on what the original intention was and what was basically the decision-making factor. And then, of course, in respect of litigation, so when you have poor documentation, how do you defend this going forward? How creative does the tax administration become here? And this is the perfect handing over to Catalina, who will refer to some of the cases from a Latin America perspective, and we will hear some of the issues again, I guess.
Okay, thank you, Lars. Marina, could you please move to the next one? Yeah. So here we're gonna talk about some cases that we found around the globe, especially in developing and less developed countries. As Lars says, this is a question not only about tax planning, but also about how you prove to the tax authorities that you really are in front of an LDR. The main discussions that we found were, first of all, about tax restructurings, obviously. So we have the Piaggio case, that is an Italian group that by a contract change its subsidiary in France from an exclusive distributor to a commercial agent. Not exactly our LDR, but the example can be very useful to the problem that we are taking. Obviously, the tax authority said, well, and for this operation was paid zero compensation for it, and obviously the tax authority said that if the subsidiary in France was going to get a lower revenue, it had to be compensated for that. And the judgment of the court obviously was in favor of the tax authorities. Then we have a second group of case law or cases in which the tax authorities would pretend is to reduce the expenses that the taxpayer or the payers are showing in their income tax returns. So we have this case of Aruba versus PriceSmart. For those that are not familiar, PriceSmart is a multi-Latin enterprise that is devoted to the retail economic sector, and what the tax authorities said is that PriceSmart in Aruba was getting losses during several years. Its position as a low-risk distributor. The tax authorities were the ones that characterized PriceSmart as a low-risk distributor. PriceSmart at all time rejected that position. But in the end, well, we didn't have a judgment in this case, because in the end it was they came to a settlement, and they decided, to reduce the losses in a happy medium between what the tax authorities wanted and what PriceSmart was asserting. In Zambia versus Nestlé happened exactly the same, and Nestlé in Zambia said that its subsidiary was not a low-risk distributor, and that it was bearing some expenses that were getting the company to get losses during also different years. And in the end, the tribunal, this is a funny case, because in the end, the tribunal ruled in favor of Nestlé, but not because of the problem of the LDR, but because the tribunal found that the tax authorities had made an assessment without enough evidence, and mixing economic concepts and doing funny things that the tribunal said they were not acceptable. But in the end, the tribunal said against the position of the company that Nestlé was in fact a low or a limited risk distributor, something that Nestlé always rejected. In Banson Optics versus India happened the contrary. In the end, the tribunal said that the tax authorities had not been able to demonstrate that Banson was an LDR, and that it was a full-fledged distributor, and for that reason was entitled to the losses that the tax authorities were rejecting. And now we have currently, so we don't have an outcome yet, litigation cases in Peru versus local consumer products companies. These big companies are being categorized by the tax authorities as LDRs. And the problem with the tax authorities is that they are finding that these companies are getting more losses than the ones the tax authorities consider reasonable, and so they are being rejected of some of their expenses. We also have obviously cases in which the tax authorities take or reject the consideration of a real LDR in order to increase the revenues. So now we have in Colombia some cases with oil and gas commodities distributors, because these companies are all the time showing that they effectively are LDRs, and so they have the right to a lower remuneration on their activities. But the Colombian tax authorities consider that they are full-fledged distributors, and they are comparing their operations with normal distributors. So they are trying to increase their income. We'll see what's the outcome on these cases. And I would say, or we would say, that the last typical discussion on LDRs is the transfer pricing methods to find the arm's length range. And this is because the low risk distributor has a lot of problems in order to make proper transfer pricing studies. So, for example, in Mitsubishi, India, the tribunal accepted the position of the taxpayer that somehow these companies can be compared to service providers, and so that the company could take the path to use comparables between the services providers, and that it was okay, and the tribunal accepted the position of the taxpayer. We also have this problem with Colombian tax authorities, that they consider that the comparables and the methods should be aligned with all the functions, risks, and assets of a regular distributor. Marina, could you please move to the other one? So after checking all these worldwide problems that we see that are more or less repeated, so the less developed and developing countries in which you get LDRs, they want the companies to behave as if they were full-fledged distributors. But on the other hand, full-fledged distributors are being treated as low-risk distributors if they are giving more losses than the tax authorities consider acceptable. So we have very key points at stake in which we have to be very careful as tax advisors and as tax persons within enterprises. So first of all, the same meaning of LDRs. So Lars already talked about this, but the characterization is always a problem while doing the transfer pricing studies and while defending the transfer pricing studies that others did when a tax litigation comes. And the problem is that the LDR is neither a full-fledged distributor nor a commissioner. So it is something in between. And you have to measure how this lower risk distributor, or how low are the risks and functions and assets of that LDR, because you have a range. Probably you have a range in which you have a distributor that bears no risks, but then you have another one that bears little risks. And then you have another one that has more, but in any case less than a full-fledged distributor. So you have to measure that, and you have to provide with evidence of that. Second, the comparables. The literature says that it is very difficult to find comparables of LDRs. So probably when you want to find comparables, you go to the full-fledged distributors and you have this list, but then you have to make so many adjustments to the transfer pricing studies that probably they are not reliable. So always the question would be, should I take the other distributors as comparables, or should I take service providers, or should I take others as comparables? And that is very difficult. If you have full-fledged distributors as comparables, you will tend to over or underestimate your profits, probably. because if you are an LDR, probably your profits will, will remain the same during the time, because as you are not bearing risks, it doesn't matter what happens with a product that is being sold by in the end, because you don't bear that risks. So if you use regular distributors, you can tend to over or underestimate. Services providers, there are literature that says, as we already mentioned, that probably in that segment you can get the best comparables, because in the end, if you are dealing with merchandising on which you bear no risks, and you have the property just for instrumental purposes, probably you can take these services providers as comparables and to do little adjustments that probably are more reliable than if you take the other way around, which is starting with the distributors. Then the transfer pricing method. So in general, you always need to find the most appropriate. As Lars already said, it is the most common method to use in these cases is the TNMM. But there is also a discussion, and you find a lot of transfer pricing studies of LDRs, in which you find a kind of mix of methodologies. Because if you for some reasons are characterized as a service provider, you can, for example, for the transfer of goods, use a pass-through and use a cup in order to measure what is the part that corresponds to that transfer of goods, for example. And for the rest of functions, you can use it at the NMM using comparables that perform similar functions to the ones. And the last thing is that you always need an optimum defense file in these cases. So multinational companies, especially in these countries, be very careful so you don't get characterized as an LDR not being an LDR, or that you are characterized as a full-fledged distributor being an LDR. So I think that you have to be very careful with that. So an optimum defense file has to have evidence about your risks, your functions, your assets, as any transfer pricing, but in a very, very, very particular way, in a very detailed and also documented way. It is very important to have the time and conditions of property, because if you're a limited risk distributor, probably you will be the owner of assets for a limited amount of time, and it is important to determine, how long is that, and what happens when you are the owner of the assets. So. The most proper thing is to say that nothing happens. So even if you lose in that case, the inventories, probably you don't lose anything because of your role as an LDR. That is the ideal position. Quality conditions. So what if you usually you don't add any value to the inventories, to the goods, so that is important. That is very reading. The managing of the operation, who is the owner of the operation, who is doing market research, who is dealing with clients, who's the clients are of. All these things are important. The budget, usually an LDR takes a budget, and the parent company has to fully provide this company with resources to cover the budget. Who bears the exchange rate risk, the pricing risk, third parties liability. So what happens if something happens? What happens with insurances? the history of the operation is very important. What I see here in Latin America is that some of these companies that are being recharacterized as full-fledged distributors have a full history in which you can see that they started by getting locally products in order to sell those products in third markets, and having all the control of the operation, to an operation in which they set up a company just for logistics or for cultural grounds, or for facilitating the operation without transferring other functions, risks, and assets to the local company. That is very, very important to bear in mind. And obviously, all the documents that you have, the master file, the local file, the agreements. Be careful. So mind the wording of the agreements, because sometimes you see that in practice you do one thing, but in the agreements there's written completely different things. So you have to be very careful with that. And obviously that the accounting books and the reality perfectly match with the agreements that you've signed. So now I will pass the podium to Lars. Thank you very much.
Yes, thank you, Catalina. Maybe before we come to the next slide, I have one question that may be interesting also for the rest of the group, and maybe Catalina, you also want to jump in and tell your view. So the question would be, if we have a LRD structure and now we have the COVID-19 situation, so would we expect that an LRD can also be in a loss situation? So this is a very interesting question, because first of all, we have this question in Austria, at least in a very general in very general matters. So how does a pandemic now affect transfer pricing setups that are already in place, and how do we deal with it? And so my quick answer would be yes, of course. I think it could be. And to maybe structure it a little, why could it be? So first of all, in case of a transaction net margin application, how do you earn your profit at the end, or your taxable profit? Because the question is, are you in a tax loss situation? Of course, if you don't have any turnover at all anymore and you still have cost, then yes, of course, cost can exceed the turnover there. So this would be merely factual, where you have accounting loss. Question is, does this also go through the tax loss at the end? Because there you have a separate agreement maybe with the tax authorities, where you simply base your margin on turnover, and this cannot be zero. So you cannot have a negative turnover in this respect. And then the other question is, if you have the transfer pricing setup, can you amend it in times like these? And I think there, my understanding would be that yes, sometimes the tax authorities would even be open, that you can somehow dilute what you put already in place in the past. Of course, as soon as they realize that you do tax structuring and just take the pandemic as a reason, then they may be reluctant. But from the outset, yes, I would expect that this may be the case, that you are in a loss situation there, despite the fact that you are in a low risk scenario.
Yeah, I want to interrupt. Sorry to interrupt, but we are in fact using that argument in the cases in which the tax authorities are recharacterizing the low risk distributors as full-fledged distributors. Because what we are saying is, now obviously we are facing assessments of previous years, but now with the COVID situation, especially with the commodities sector, what we are saying is, look, I am an LDR, and one of the evidence of this is the situation of COVID, because the international markets lower the prices. But in any case, I am not giving losses. I'm not giving losses because my parent company is providing me with everything I need to cover the operation. So the losses will be suffered by the parent company that acts as a full-fledged distributor. They are the ones that have losses in bad times and profits in good times. I have more or less the same, no matter I have losses or profits.
Thank you, Catalina. Maybe there's another question that perfectly fits for you. What would be the benefit at all, or why are the tax authorities claiming that this taxpayer is to be considered as a full-fledged distributor? What is their benefit in this argumentation?
Well, obviously, if they characterize, think in a country in countries like, Latin American countries. So it depends on the position of the company and the position of the tax authorities. But here, if I am assuring that I am an LDR, obviously I have less profits, also less losses than an ordinary one. So the tax authorities, if they consider that I am a full-fledged, obviously it is because they are claiming for more profit. So they are doing adjustments on this basis.
Yeah, so this is the same what we see here. So typically they would not go that far that they really claim it's a fully fledged distributor taking all the risk, but typically they would try to at least argue that you are taking care of more functions that you originally claimed or that you consider yourself. This is typically when they figure out, as Catalina mentioned before, that some of the agreements may not be in line with what we actually do, or in general, in cases of tax rulings. This is typically the case where they afterwards find out that the fact situation in place is deviating from what was done. But there, typically, they would simply try to raise the margin, because what I can see in practice, at least the Austrian tax administration, they are more reluctant to argue in favor of a totally different transfer pricing method, rather than simply increasing the margin or saying the margin that you used is out of the range. Therefore, we go to the median of a higher range or something like that. Okay, well, the question goes on in contrast to the LRD. What are the characteristics of a full-fledged distributor? So this is where I came from at the beginning with the functions. So the full risk distributor would, for instance, have an inventory. They would put goods on stock in order to be prepared if more customers are coming. But they are also on the risk side. If there is a pandemic and nobody is buying these goods anymore, they would suffer a loss because of they become obsolescence or something like this. So they would take more risk in respect of creditor risk. There is they would be responsible, and they would have to invest their own money in order to do market research and things like this. So while the low risk distributor would have a continuous income with a low margin, the fully fledged distributor would have all the benefits of a good year, but also all the risks with maybe a huge loss in times of a pandemic like in this year. Or maybe LRD is a bad example, because apparently goods are still sold if you have a look at Amazon and so on. Okay, thank you. Then Marina, please, to the next and last slide. And this is just one particularity I wanted to add from a European perspective here, which is outside of transfer pricing, but still connected to transfer pricing. And we had this discussion here over the last month, whether a low-risk distributor can be a controlled foreign company under the CFC regime of the new anti-tax avoidance directive. So typically, as background, Austria never had CFC legislation, however, was now obliged to introduce it due to the anti-tax avoidance directive. We did that, and now just one particularity, because we are talking about low-risk distributors. I'm not going into any details about when do you qualify as CFC, when are you a controlling entity, and so on. However, if you choose a certain type of implementation, basically at the end it comes to a point where you have to figure out, do we have certain types of income? This is typically passive income like royalties and stuff like this. However, here there's one category of income, is income from invoicing companies. So this is the wording of the English directive here, and this is defined as income from of a corporation that typically sells goods or services and or acquires them from associated enterprises. So there is one category is, or one question is there, and this is the English version, that you have to purchase from a group company and you have to sell to a group company. So, however, there are deviating language versions. So, for instance, the German version would be that you either have to sell or to purchase from, which is, of course, on one side you have a third party. So the typical low-risk distributor would be an entity that at the end sells maybe to third parties. So this interpretation makes a lot of a difference there. Austria took the less restrictive approach, where you have to buy from and sell to group companies. It's not sure whether this was really intended there. And then you have no or little economic value. So what is this is actually not really sure. The low risk definition is that you have low risks, and typically you would expect that you also add low or little economic value. From our understanding, it comes to a point where if you have the term invoicing companies, that this will typically catch the offshore invoicing companies, where they are not involved in the economic activities at all, but simply send the invoice, so you have the profit on account somewhere offshore. This would be the typical company there. However, how this is to be interpreted at the end, the European Court of Justice will have to decide. And if we have this offshore invoicing company in our mind, the very interesting question where we come to what we discussed before is CFC taxation versus transfer pricing. So what is the actual profit that you would allocate under CFC, or attribute under the CFC regime there? Because the general position would be, you can only have taxable profit there that is attributable to this invoicing company from a transfer pricing perspective. So if you simply send invoices out and pay invoices without doing anything, and at the end you have a huge profit there, you would likely have to make a transfer pricing adjustment offshore somehow, somewhere, at least when you're in relation to a developed country applying OECD principles. And then the question would also be, is this correction in relation to the controlling corporation here, or is it in relation to some other group company? So at the end, you may end up with a situation where you have a huge transfer pricing adjustment. You reduce the profit of the CSC from a transfer pricing perspective, and then there is nothing left to attribute under the CFC regime. And you come to a point where the CFC, the controlled company, may not even be affected, and where the entire provision complex. However, this is just are also affected, and I think we are 1 minute ahead of time and perfectly in time.